This is Law Journal.
80% of all tobacco products sold in this nation fall into the light cigarette category. And the tobacco companies say light cigarettes are all about flavor, and the plaintiffs' attorneys say it's all about fraud. Are light cigarettes the new frontier, or the latest addition in the tobacco litigation wars? Good evening, I'm attorney Christopher Naughton, and welcome to this live edition of Law Journal. Tonight, for those of you in Philadelphia and the greater Lehigh Valley and parts of New Jersey, we're going to open up our telephone lines and we discuss what may become the latest round in tobacco litigation. It's all about light cigarettes. I have two attorneys joining me tonight. They'll be squaring off, although they are not in the same studio. We have one here in the studio with us, one joining us by satellite from New York City. Here in the studio tonight, plaintiff's attorney Stephen Scheller from Scheller, Ludwig & Beatty. As you can imagine, the lead partner with that firm, known for their medical malpractice, personal injury, and product liability work. Specifically, they have spearheaded a numerous product liability cases throughout the country dealing with phen-fen breast implant litigation, and of course the latest round of tobacco litigation. Some of Steve's colleagues call him a proponent, a pioneer in the light cigarette litigation scenario. And joining us tonight from New York City is William Ohlmeyer, and Bill Ohlmeyer is a vice president and associate general counsel with Philip Morris Companies, although from what I understand, Bill, that name's going to change pretty soon.
Well, they may have a new business card come April if the shareholders approve it.
Okay, and what's the name of the company going to be now, Bill?
The Altria Group. The tobacco company would maintain the name Philip Morris. The Kraft would still be Kraft, Miller would still be Miller, but the company that owns each of those companies proposes to change its name to Altria Group, Inc.
Okay. Thanks for joining us tonight, Bill. I know that you have headed up various defense litigation with Philip Morris, and as a matter of fact, attorney William Ohlmeyer was a partner with Shook, Hardy & Bacon in New York City a number of years ago and represented numerous tobacco companies when it came to defense of these issues. Folks, I want to remind you, a telephone number will come up on the screen, lower left-hand corner. There it is, 1-800-426-4625 is the number here in the studio. We're going to do our very best to field a couple of phone calls before this half hour is over, but don't bet on it. I think this is going to be a fairly intriguing show tonight. Let me ask each of you, and I'd ask you to answer, this is the way I normally do the show, whether we have two guests or four, and that is in 50 to 100 words, if you will. Light cigarettes, the production, the dissemination, the advertising of light cigarettes, has it been, is it a perpetration of fraud on the American public, and is it provable in a court of law? Let's start with our plaintiff's attorney, Stephen Scheller.
Well, historically, this was sort of a mystery with the light cigarettes. What happened ultimately was we ended up in a situation back in 1997 where we always knew people smoked differently. They puffed the cigarettes with different parameters, and we always knew the cigarette packs had the same warnings on them, whether they were light, ultralight, or so-called full-flavor cigarettes. But back in 1997, I subpoenaed at home a fellow named Alan Rodgman, who was a past research director for R.J. Reynolds Company, not Philip Morris. And he had at home a number of documents that had never, to my knowledge, many of them had never been seen before in any types of litigation. Now,
keep in mind, Steve, you're about ready to run out of your 100 words, right. So I'm going to give you a shot.
Well, as a result of finding those documents, I realized that a major deception had been going on, that the industry had begun in the 70s a design parameter to create cigarettes which tricked the FTC, the Federal Trade Commission Cambridge filter, so as to record a certain amount of tar and nicotine level on the filter, but not anywhere near close to what human beings actually ingested.
Okay, so I would say if I could sum up, then clearly from plaintiff's standpoint, you believe a fraud was perpetrated on the American public, and you and other plaintiffs' attorneys are going to go ahead and prove this in a court of law. Do you feel pretty confident that you can do that?
Well, I'm not alone in that at this point. The Canadian health minister agrees. I believe the Israel...
But do you think you can do it?
Oh, sure.
Okay. Bill Ohlmeyer, let me also give you a shot, and again, you'll get as many words as plaintiff's counselor got. Is this about consumer fraud? Is this about fraud? Can plaintiffs' attorneys, have they, and can they prove this in a court of law?
No, absolutely not. This is about lawyers trying to avoid the law and avoid the facts
in order to create lawsuits that will survive motions to dismiss. There's a warning on every package of Marlboro Lights that's ever been sold, and it's the same health warning it's the same health warning that the Surgeon General requires to be placed on any other package of cigarettes. There's no different warning on a light cigarette package than there is on a Marlboro package, and both warnings tell people who smoke that there's a risk of developing lung cancer if you smoke those cigarettes. They haven't been advertised and they haven't been marketed as being any less hazardous or any safer than other cigarettes, but they do certainly deliver less tar and less nicotine when you measure them using the FTC method, which is what the government has told tobacco companies they're supposed to use when they try to compare the delivery of tar and nicotine from one brand to another. So what you're seeing in this litigation, I think, are lawyers trying to create something that doesn't exist, and that is some sort of argument that the government was somehow misled, or that consumers who have purchased these cigarettes in packages labeled in accordance with federal law have also been misled, both of which I think they're going to have a very difficult time proving. In fact, I don't think it can be proved, and I'm optimistic that we'll be able to successfully defend these cases because these issues aren't new, and these facts go back 30 or 40 or 50 years, and when you combine the law and the facts, I think the jury will agree with us that people who smoke these cigarettes, like other cigarettes, have made informed choices about cigarette smoking.
Bill, I don't know if you can hear me or not, but in essence then, you don't see that there's a whole lot of difference in this litigation compared to the litigation we've seen, let's say, at least since Chip alone in the mid-1980s.
No, not at all. What's different about this litigation is the package. It's been aggregated into a class action that's designed to avoid the effect of the law, which for the most part has prevented tobacco cases from being litigated as class actions. In fact, in these cases, there aren't even injured smokers bringing claims. The people who are plaintiffs in these cases are claiming an economic damage, not personal injury. And it's all done in an effort to promote the idea of litigating these cases as class actions as opposed to trying them as individual cases brought by smokers against tobacco companies.
Steve Scheller.
Well, you know, it's interesting that Mr. Ohlmeyer has that to say. However, let me take you back a step, and let me just, rather it be my statement as a lawyer, because let me read to you a statement from the Department of Health in Canada, from the health minister, from his special panel. And
that was a report that I think was just relinquished earlier this month, I think November of 2001.
Right.
Okay.
November 1st. Historically, this perception was created by tobacco industry marketing, which suggested that light and mild cigarettes deliver less tar and nicotine to the smoker. This perception was compounded by public health pronouncements that said that reducing tar intake would likely reduce the risk of smoking-related diseases. However, due to cigarette design, human smoking behavior, example addiction, and the product modification and promotional activities of the tobacco industry, no actual reduction in tar intake was achieved. As a result, there is an urgent need to prevent further deception and to remedy existing misconceptions. What else happened here is that the U.S. Court of Appeals for the First Circuit, just in the last month or so, called this a deception. And the point of it all is that this is not just lawyers' tactics. This is, in fact, an action taken by the tobacco industry to create a trick and deceptive product, to trick the public into thinking that light and ultralight cigarettes are somehow better for their health. And it's the same thing they've always done. The spots on the leopard haven't changed, and I'm sorry to see Mr. Ohlmeyer after September 11th and changing the name to Altra. They're not changing their methods, and they're not changing the product. I think the name would have been better. I heard somebody on NPR mention the name Almort instead of Altrua. Almort standing for French, I think, for death.
And then just to make, we're just making a point, if you just tuned in, Philip Morris will be changing its name shortly. Attorney Ohlmeyer, do you believe that, and again, I know it's hard for you to gauge the pulse of the American public, but when we talk about light cigarettes, are we predominantly talking about health benefits, or are we talking about flavor? What is the position of at least Philip Morris?
Well, I got to tell you this. It's typical of plaintiffs' lawyers who don't want to talk about the law and don't want to talk about the facts To inject a sentence about September 11th into this discussion just demonstrates what goes on in this kind of litigation. The lawyers don't want to deal with the facts, and they don't want to deal with the law. The facts are there is a warning on every package of Marlboro Lights that says smoking these cigarettes can cause lung cancer.
I understand, and Bill, and that's how you started. That's how you started the program.
Sure.
But what I'm trying to gain from both of you is that when we talk about light, and we talk about light cigarettes, do you believe it's the perception of the American public, or at least the position of Philip Morris, that it's really pertaining more to taste and flavor than it is to a health benefit or purported health benefit?
That's what the Marlboro Light advertising campaign over the years has talked about. The taste and flavor of a Marlboro in a lowered tar and nicotine delivery cigarette. And when you have to have a standard by which to test these things. It's the Environmental Protection Agency gives car manufacturers a test that they're supposed to use to determine whether a Ford Taurus gets better gas mileage than a Chevrolet Monte Carlo. But the way you drive the car can affect your mileage. When the Federal Trade Commission in this country in the 60s decided that they wanted to create a standard by which you could compare the tar and nicotine delivery of one cigarette to another, they said, and they knew because Philip Morris told them and told the public, that people might smoke cigarettes in a way that can create differences in how individual people smoke and what these cigarettes deliver. But when you compare them using this standard that the government has given us, a Marlboro Light delivers less tar and less nicotine than a full-flavored Marlboro Red. And people who smoke will tell you that there is a difference in the taste and the flavor of a light cigarette as compared to, and we've already used the words, each of us, full-flavored cigarette. So then it's the position, then, Bill, it is the position of the tobacco companies, or at least, again, you're speaking for Philip Morris, that light cigarettes are designed to deliver less tar and nicotine, that in fact they do deliver less tar and nicotine, and in essence they are a healthier product than a full-flavored cigarette. Well, Philip Morris has never promoted these cigarettes as being healthier than full-flavored cigarettes.
But you're saying, Bill, just so I understand, you are saying that the light cigarette brands will deliver less tar and nicotine to those who smoke.
Even under exaggerated smoking conditions that have been produced recently in some tests in the state of Massachusetts, that is the case. A reduced tar and nicotine cigarette will deliver less tar and nicotine than a full-flavor cigarette. And that's one of the things Philip Morris and other tobacco companies have done. They have produced cigarettes in a range of tar and nicotine deliveries because for a variety of different reasons, the people who smoke, the marketplace, have requested and demanded that. And there was a time where, in fact, the government and others suggested that reduced tar and nicotine cigarettes should be produced and brought to market because they might have the potential to reduce the risks associated with smoking. It turns out that some people who thought that might be the case have since changed their mind or have since decided the evidence is inconclusive. But from very early days in the smoking and health issue in this country, the people who did the research on cigarette smoking, the people who advised the government on these issues, promoted and encouraged reduction of tar and nicotine as a potential for reducing the risk associated with smoking.
All right, I'm going to give the floor now to Steve Scheller.
I'd like to get some equal time here, Bill. Firstly, your comment about the Ford Taurus mileage is very interesting. The situation with tar and nicotine levels in cigarettes, according to the method used by Philip Morris for testing them, is essentially in a car, you get 23 miles per gallon on the highway and 18 on the city, and everybody drives differently. But you might get 22 miles, 16 miles. With Mr. Omeyer's cigarettes, Philip Morris's cigarettes are altruist cigarettes. What you really get is instead of the 23, which is on the label, you get the equivalent of 10 on the highway and maybe 3 in the city. If that happened with any automobile in our country, and that mislabeling of false representations, that's called a deception. And that is exactly what's happening with these cigarettes.
Now, let me ask you, from what I understand, again, the Canadian National Health Minister, and I think the Canadian government did a number of, correct me if I'm wrong, gentlemen, their own independent tests. And from what I gleaned from their reports, the Canadian National Ministry stated that there was very little difference between the tar and nicotine intake between 100s, full-flavored cigarettes, lights, and ultralights.
That's exactly.
That's what I've heard.
That's
anyway.
exactly what happened. And what the Canadian minister, health minister, said. And by the way, the Europeans say this, the special committee, the British Parliament, and I predict ultimately when we leave the lobbyists out of the situation and the political contributions, so will our health department. And Department of Health and Human Services. The Canadians say smokers report that low-yield cigarettes have a milder taste. This is Mr. Omeyer's argument. This is in part the experience of inhaling diluted smoke. Because of compensation, smokers do not receive a lighter burden of toxins. They simply inhale a greater amount of air, diluted smoke. This subjective experience with low-yield cigarettes compounds the deception of light and mild descriptors, as it reinforces the impression that these cigarettes are safer. Now, any smoker, and most people know that that's true. So for Mr. Omeyer to come to this studio today and make these kinds of representations sadden me. And I think September 11th is apropos. I don't think this is just plaintiffs' lawyers. I think there has to be a change. And I would extend my hand of friendship to Mr. Omeyer and Philip Morris to ask them to join in an effort to get rid of this deception, to get rid of this light and labeling, mild labeling, ultralight labeling, and tar nicotine, and find a way to do what they should have done back in the early 70s, which is find a way to truly make these cigarettes deliver the lower tar and nicotine. Yes, all cigarettes are not good for you and are health risks. But most importantly, these cigarettes are the ones that were supposed to substantially reduce health risks, and they don't. So to simply say that all cigarettes are unsafe, which is what Mr. Omeyer is trying to say, is not apropos to the issue here. Are these cigarettes deceptive? The First Circuit Court of Appeals says the Canadian government, the English government, the Israeli government, and I predict the United States government agree with that. And now it's time to own up and take responsibility and say, we made a mistake, we were wrong, we deceived the public, they got caught. Now's the time to change it. Again, Mr. Omeyer, I extend my hand to you. It's time to sit down and stop this conduct and work out something that we can all do to help these people who are addicted to your cigarettes and take steps to see what we can do to change the way you do business.
I said I didn't want filibustering tonight, so we're probably going to have more conversation as we go throughout this program. I want to remind you, 1-800-426-4625 is the number here in the studio. We're banking or holding on to a number of phone calls because we want to get down to the essence of tonight's program, which is light cigarette lawsuits. And this is, and Bob, I'm throwing a bit of a curveball at you here, but if you do have that graphic ready for us, light cigarettes, thank you, have dominated the market and do dominate the market today. If you see back in 1967. And again, for those of you who wonder what a light cigarette is, essentially it's 15 milligrams of tar or less. If it's ultralight, it would be under 6 milligrams. But we're talking about this broad category of light cigarettes. 2% of the market was light. In 1980, it ballooned up to 44.4%. And now, some 20 years later, we're talking about over an 85% market. And I'm just wondering what the dynamic is behind that as to why so many more people have reached for light cigarettes. Now, Bill, if you're saying that, again, it's more about flavor than it is about the intake of tar and nicotine, is it the American consumer that enjoys the taste of Marlboro Lights, the most popular light cigarette, the most popular cigarette on the market, compared to full-flavored brands?
Yeah, I think that's obvious, that in any kind of consumer, and especially a competitive consumer market, regardless of the product, the manufacturer supplies what the consumer demands. And there has been an increasing call over the years for cigarettes with lighter tastes, and that it's consistent with other products in other categories besides cigarettes. That over the years, people have just decided that they want something that is a little lighter and a little milder than some of the full-flavor cigarettes and some of the non-filtered cigarettes that were sold in the past. You know, over that same time period, the average tar and nicotine delivery in the cigarette market's been reduced dramatically. I think if you go back to the time of the Surgeon General's report in 1964 and move forward, cigarettes today deliver nearly 70% less tar and nicotine than they did in the 1960s. all because that's what the marketplace demands. And these manufacturers, like any manufacturer of a consumer goods, supplies what the marketplace demands.
Now, Bill, do you think that this litigation, though, with light cigarettes takes tobacco litigation a step further? That you said earlier, it's not so much about personal health issues, it's about the bottom line, it's about money. Is it more about consumer fraud than health?
No, there's very little new here. These are facts, many of them which go back 40 years, that are being dressed up in a new type of lawsuit, a so-called consumer fraud case as opposed to a personal injury case. The Federal Trade Commission developed the test that Philip Morris uses to measure tar and nicotine delivery. At the time they did that in the 1960s, Philip Morris wrote them a letter that said, people smoke cigarettes differently than these machines. The amount of tar and nicotine an individual smoker may get will vary. And they said, we understand that. And they also were aware of this idea that has been discussed this evening about compensation, about people smoking differently at different times. All of those are not new facts. None of it is new to this litigation. It's been part of these smoking and health cases over the past several decades. And what we're seeing now with this litigation is an effort to create something a little new and a little different in order to attach a little different kind of emotion to it in order to avoid the effect that the law and the facts have on cases and claims like this.
Steve Scheller.
There's a couple of statements that Mr. Ohlmeyer just made. Number one, tar and nicotine levels haven't dropped one drop since the 50s or 60s. What happened
That's
is look, let me talk. You're filibustering now. And in 1970, what you guys did is you were going to face an order from the FTC saying, we're going to make this a rule to use one system for measuring tar and nicotine because you were using all kinds of systems. So what you did is you said, well, you know what, we'll voluntarily agree to do it, but we'll have some fun with the FTC. We will begin a process of designing these cigarettes to make an elastic cigarette, so that we will trick the FTC, the public, and the Cambridge filter. And the more we design our cigarettes to be elastic, the better trickery and deception we perpetrate. What you did is a disgrace. What you did is you took a lower tar and nicotine, and instead of lowering them one iota, one drop, you began the deception of making cigarettes designed so that they would get 23 miles a gallon on the FTC filter, but 5 miles a gallon in the human being. And you know you did it, and for you to stand there and say you didn't is just terrible.
Well, no,
and
we'll
I
see,
think
we'll
it's
see if you can
unconscionable.
prove that.
I think it's unacceptable, and I think it's time for you to step back and take a look at the whole world. You've been denying that nicotine's addicting. Now you're denying the deception of the light cigarette.
We'll see if you can prove that, because the last jury that heard that argument returned a verdict for Philip Morris last Thursday in West Virginia.
That issue was not in that case.
It most certainly was.
And you got hit.
It most certainly was.
Don't even talk about that case because it has nothing to do with the light theory.
That's what's great about our legal system.
Have there been any cases so far? I'm going to both Bill and Steve. Have there been any cases so far that have stood essentially on the light cigarette litigation issue? Stood or fallen on that issue, or it has been just a plethora of issues that have been thrown out on the table, very little to do with just light cigarettes?
No, it's always it's been an important part of what, as you've seen this evening, can be a very emotional and very enthusiastic attack on the company. Very good lawyers in very difficult cases across the country have made those same arguments, and juries have continued to return verdicts for Philip Morris on that issue.
What about Shabers in Madeline Shabers' case in California?
Got hit for
from what I understand, now I don't know what portion of the case was founded on light cigarettes, but it was a pretty hefty
$50 million punitive verdict just affirmed the other day by the Court of Appeals, where they pointed out the deception in California. And part of that case, there has been no case tried solely on the concept that we're talking about.
You concur, Bill? No case tried solely on the concept of light cigarettes?
Right. Correct. Although it's been an important part of so-called class actions and reimbursement cases that have been tried. And it's not an issue that is wanting for trial time in what has been a very active litigation docket this year. It was a big part of the case that was tried against Philip Morris in Brooklyn this summer. It was a big part of the case in West Virginia. It's obviously an issue that has a lot of litigation sex appeal. But when a jury has the opportunity to hear the facts, apply the law the judge gives them to the facts, they conclude that people who smoke light cigarettes, just like people who smoke other cigarettes, have made informed choices about smoking and are responsible for those choices.
Yeah, Mr. Omar's company is right as we speak at the moment trying to argue that we have no right to try this issue because it's been preempted by governmental action. In fact, one of the key things that's happened in tobacco litigation over the years is plaintiffs have been forced to go to court with their hands tied behind their backs because of legislation which the industry was successful in obtaining and tricking Congress into passing, or arguments to courts which essentially talk about preemption. And what they do is they're afraid to let these cases be tried before the jury with all the facts coming out on both sides. I say to you, Mr. Omar, let the facts come out on both sides.
Well,
we'll be happy to let a jury decide, but don't tie our hands behind our back with some tricky legal technique of preemption, which bars us from putting the evidence in.
Now, you wouldn't want to apply the law. You wouldn't want to apply the law to these cases.
You didn't get to be vice president of your company by not being a good lawyer. You're a very good lawyer. You've been successful as Shirkardi has been over the years.
And you don't think the law should apply to Philip Morris the same as it applies to your clients?
No, it doesn't.
The law is the law.
And I think the law has been very unfair to plaintiffs in tobacco litigation.
Well,
and I think you
and an
able lawyer,
you have the opportunity. You have the opportunity.
And this is a very good legal question. It's a good jurisdictional question, or at least it's a question of the law and procedure, I should say, which is great for the lawyers watching tonight. We're just about out of time. I want to thank. We've got a minute or two, but I do want to thank you folks for watching tonight. Let you know that if you need some more information about any upcoming Law Journal program, go to our website, www.lawjournaltv.com. Check out our upcoming schedule. Call us toll free at 888-78-LAW-TV or email us. And we want to thank the Legal Intelligencer for making tonight's programming possible. Just a minute or two, gentlemen. Where do we think this is going? More litigation, more time? Do we see any kind of settlement here, or do we see prolonged, protracted litigation with light cigarettes in the next, let's say, 5 to 10 years? Steve Scheller first.
I think the Achilles heel is finally here, that the industry will either work at it and be honest and straight up with the public, get rid of this deception, and work out a way of resolving and helping smokers cease smoking, pay for smoking cessation programs, take those steps that are necessary to really begin the true process of developing safer products. I'm not saying we're putting cigarettes off the market. I'm saying let's find a way to help these smokers who want to stop. Let's stop deceiving them.
All right, and Bill, I'm sorry, it's about 30 seconds. Is this going to be tougher for you to defend light cigarette cases in the next 5 years, or just as easy?
There's a warning. There's a warning on the package of light cigarettes that says the same thing as the warning on the package of other cigarettes. It's a warning that Congress has decided is adequate to inform the public about the risks of smoking, and that's the law in this country, and it should be applied fairly and equally to us, just as the law allows these claims to be brought, but they have to be proved. And they're a lot more difficult to prove than they are to talk about on television or in the newspaper.
Bill Ohlmeyer joining us from New York City tonight. Bill, thanks. I hope you join us again. Steve Scheller here in the studio. For all of you, I'm sorry we couldn't take your phone calls tonight, folks. But Bill and Steve, I hope we do it again. For all of us here at Law Journal, thank you for joining us. We'll see you right here on Law Journal. Good night now.